These people weaponize Ipsy PD? Okay, you can stop there because that request is denied. Without more, that is absolutely denied. If you're going to tell me some landlord decided to weaponize the police department,
well, not that
that's going to be a complaint you're going to have to address as the police department. I don't believe it. What? Because I don't know who you're referring to as the keeper of the record. Where does a deposition help with that? Go ahead. I don't care.
Good morning, Ronnie Haddad for the plaintiff.
morning, Your Honor. Master Chair, I think requesting permission, I guess, pursuant to Rule 8120, restricting court rules. I'm under the supervision of Attorney again, and I'm just what's in this.
Permission to practice. Good morning. Permission to practice is granted. All right, where are we on these cases? We may have a procedural issue. We think this, Haddad, you attempted to file a response
Yesterday, however, we weren't aware that there was a age limit.
Okay, just so that we're aware, I was not aware of that either. I'm going to be checking into that because as I'm informed, somebody said it was 15 pages.
Correct.
Well, if they're going to do that, to be blunt about it, they should do something consistent with the court rules, which would limit a brief maybe to 20. So I don't know how I tell. This is what happens when lawyers don't make decisions. Go ahead. I'm sorry.
All right, we can proceed. We can argue our sister counsel can argue her motion, and I can respond orally. I mean, I am prepared to proceed on these two cases with our response.
Okay, I guess. Yeah. I mean, I'd certainly like to read through your response. I only got them this morning, so I haven't had an opportunity to do so, but I guess I'll allow argument to continue. I may not give a decision on it.
Okay.
I think, from my understanding from the last hearing, new notices were going out in any event.
Actually, we held off on sending out the new notices, Your Honor, because our position is clear on the CARES Act issue. So.
All right.
Your Honor, we would like to request additional time so we can compose a written response, written reply.
A reply to what?
To the response. Yeah, we received the kind of.
Can I just say, as a practical matter, had they on June 12th sent out new notices, which I think they would be entitled to do, we're going to be right back in court, even if I grant your motion. So I don't mind giving time for you to respond, but
You know, Your Honor, here's the thing. I mean, at the last hearing, the defense counsel presented us with a motion to dismiss.
I know.
Which was forced to be a motion for summary disposition. I think that we can proceed with arguments today if they're not ready to argue their motion, at least. And I can argue my response to their motion. I just don't think that any further delays on this. I mean, if we're talking procedurally, 21 days was the time that I should have been given before the previous hearing for a motion for summary disposition. But I received it the same day, and we responded to it within 2 weeks. We have, authority that supports our position.
Your Honor, if I may, the motion was filed not to be heard the day after. It was filed for the court to give us a hearing date that it was appropriate for the court. And the court rules do require a response to be filed 5 days by mail and 3 days by electric or personal service, electronic personal service. We're just asking for an opportunity to file a written reply.
So sorry, just for correction, I think Sister Counsel's confused. It's supposed to be 21 days and then giving me 7 days to respond. So it technically should have been filed 20 days before the previous hearing.
okay. And I'm just talking from a practical standpoint. If I grant the motion and you filed a new notice, then there's just going to be a new case. It's going to at some point moot itself. These cases will moot themselves and they will just start again.
Right, but here's my issue.
Okay.
If you grant their motion, then you're setting a precedent here, and I'm prepared to argue the basis of their motion, because otherwise, I mean, we have federal authority here that trumps their authority, their persuasive authority at best. And so I would like to have an opportunity to argue my motion, the motion, because of the fact that if you dismiss it, then we have to instruct our client to start filing 30-day notices, and that's not necessarily the case anymore. It's our position. And so you're setting a precedent here, and then.
Counsel, I have issued a written opinion
Yes.
previously on this. My colleague, Judge Washington, also issued an opinion. Hers was appealed. There was then a circuit court order, which I believe the defendants may be relying upon. However, I think that circuit court order, with all due respect to the circuit court judge, is in error. And by the way, since it did not involve my case and did not involve a specific instruction to this court, I don't believe that I am bound by that. And I think that is very, very clear. But I've heard all of these arguments before. So unless there's something new.
Well, so the Department of Housing and Urban Development issued a revocation of the 30-day notice, Your Honor, and that was effective as of March 30th, 2026. That's
new.
Correct. And that is the authority that we are basing our response, and that changes everything.
That was in your.
Correct.
That I haven't had an opportunity.
Correct.
And that's
Thank
what
you.
we're asking to reply to, Your Honor. And if you want us to proceed, you can proceed, but I think it would be.
Did you attach a copy of the revocation?
I did, Your Honor. There's one exhibit 1, and at the end, and that is the federal February 26, 2026, and it was issued by HUD, the federal organization that was also behind the 30-day.
Well, yeah, the original 30-day actually came out of a federal act, which was a result of COVID.
Correct.
And you've not seen this?
Your Honor, we have seen it, and it's actually, I think, I'll let Mr. Shea, I'm sorry, I'm jumping in, he's here to argue.
So Your Honor, the effective date of the interim final rule has been delayed indefinitely, according to the notice on March 13, 2026. HUD has now treats us as a, sorry, I apologize. HUD put out a notice saying that this effective implementation date has now been delayed and is now treating it as a proposed rule, awaiting comment and a final rule. On another point.
So is that just, then that would not be authority for this court you're indicating?
That is correct. It's not yet in effect.
Are you aware of the Mr. Dodd?
The delay.
Yes.
So again, defendants are relying on persuasive authority. This is a federal regulation that has the effective date was originally March 30, 2026. And what they're stating is that it has been delayed as of, I'm sorry, what was that? March 13th?
March 13, 2026.
Okay. It does not negate the weight can still be put on this, the federal regulation, Your Honor. I don't believe that it's I believe that it's still persuasive authority at best here. or in the least, Your Honor. So I believe that we can still rely on this, on the HUD, repeal.
Your Honor, my approach,
What is it? What are you trying to give me?
the notice that the HUD put out, on March 13th.
So I would need to see that first before you show it
Yeah,
to the
sure.
judge. And then,
Oh, sorry.
yeah, so,
Well.
no, that's it.
You have the same things.
Yeah,
Okay, thank you.
I believe so.
That.
So this is pending consideration of public comments, Your Honor. And I know that this is a process.
So is the rule in effect pending public comment or is it not in effect?
It is not in effect pending public.
What?
It is not in effect
Does
pending.
it say that?
It says,
It says it's delayed. Pending consideration of public comments.
yes, Your Honor, it says the effective date is delayed indefinitely pending public comment.
And it's just basically revoking any 30-day requirement of the CARES Act, which I don't think applies in any event, but
Your Honor,
go ahead.
since this is the notice here in question that we're discussing revokes existing HUD rule about a 30-day notice requirement. The notice requirement,
Existing notice.
yes, HUD promulgated their own rule requiring 30-day notice for specific properties.
No, they didn't. That's not how that comes about at all.
I don't think he's referring to the CARES Act, he's referring to the rule that this rule is trying to revoke.
About the 30 days.
This, because I think it would be a lot more clear if.
No, I don't think it gets any clearer. I mean, but in my mind, it doesn't need to really be clear because I don't think it applies in any event. But I'm just trying to get your argument.
Yes, so Your Honor, the CARES Act notice requirement that we are attempting to argue here is completely separate from the rule that this HUD notice is attempting to revoke. The rule that HUD is attempting to revoke here is HUD's own enhanced 30-day notice rule. It has additional requirements like informational requirements for public housing.
But wasn't that based upon the CARES Act?
Yes, it was, Your Honor, actually. It's the revocation applies to the also to the requirements for termination notices. So he's essentially, it's the same thing. It applies.
I mean, part of that rule was a result of individuals' interpretations of the CARES Act, whether or not it still continues, right?
Here's what's concerning to me. I mean,
Isn't that correct, what I just said?
I don't believe so, Your Honor. I believe CARES Act is a federal statute that, HUD obviously has no authority to revoke or rescind a federal statute. That's how the 30-day notice requirement.
yeah, I disagree with that. It is a federal agency and it has this, it's effective law.
Well, I mean, I think that's a very dangerous argument to make because part of my concern with applying part of the CARES Act is that I think the CARES Act, when I look at it, really truly falls on its own accord because there are certain provisions that are specifically COVID related. And there is one part that everybody is hanging on to that I just think falls with the entirety of the statute. So your argument that you're making now actually fits quite well in what I'm saying, quite frankly. But
yes, Your Honor, there is indeed a sunset date for other provisions of the CARES Act, such as the eviction moratoriums, but that sunset.
I know the whole argument. I heard it over and over, but
I mean, Your Honor, this is what's concerning to me is that defendants have opted to use the, you know, the court's resources to file on behalf of the defendant to, I mean, they've been given ample notice now. They have legal counsel, legal counsel has filed a motion on their behalf. And so I don't think that this is beneficial to the defendant at all. I think it's, you know, it's disheartening to me. That this is how they decided to,
How much is each tenant's monthly rent?
for Haverhill,
Yes, how much?
For $12.75 for Miss Smith.
Miss Smith is $12.75. Pardon? Miss Woods' rent is $15.58.
it's 1568, but I can double check.
And the other one was what? Pardon?
$12.75. Oh, I did wish for it. I got a job. That's what I was saying. You wished you luck on my interview. That's the word.
Oh, well, I don't know if my luck had anything to do with it, but congratulations. What is at this point plaintiff's claim on, as far as rent on, Smith?
So for Ms. Smith, her balance that's due and owing is $5,450 in rent to retain, $170 in attorney fees and costs. For a total of $5,620 due and owing.
And that's gonna go up tomorrow.
Gonna go up tomorrow.
And on the other case, how much is owed?
On the other case, it's a lower amount, Your Honor. It's $962 in rent to retain, $170 in attorney fees and costs for a total of $1,132. And so
Got it.
unfortunately, this is the route that we've decided to take here.
Your Honor, Ms. Woods dispute the amount that she owes.
Pardon?
Ms. Woods disputed the amount that she owes with the plaintiff. She has evidence of receipts that she had provided with the.
I imagine we're here in court. There's always a dispute. I just asked what plaintiff's claim was. Going back to the regulation by HUD, how long was the comment period?
So it was, comments were supposed to be submitted by, I believe, April 27th or so. So it would seem that they were supposed to be submitted by April 27th, 2026.
Just says indefinitely on the pending consideration.
No, they can't have a comment period indefinitely.
That's correct, Your Honor. The comment deadline is April 27th.
All right.
So it states that HUD is treating this interim final rule as a proposed rule due to the comments submitted. So again, I don't think that it's
Well, I've got to review it myself. And so, I understand that there might be some delay, but how much time are you looking to respond to this? Since it is just a piece of the actual thing.
Because Attorney Kim will be out of the office due to the upcoming holidays, we're hoping to request a 2 weeks time.
All right. I'm going to permit a response to that portion. I won't hear argument today on everything. I'll hear it all at one time. I will. I'm going to do two things here. I'll give you to the 14th to respond. I don't want anything else after that. Anything else after that, I'll just hear an oral argument. So, and then what is my next? Because I'm going to need time to look at everything. But
July first.
no, I'm going to need more than a week. 4th or 7th, 4th or 11th. All right. Then what I'll do is I'll adjourn this to August 4th, 2026 at 9 a.m. for a hearing on the motion. In the interim, I am going to order escrow in each of these cases. It's effective for tomorrow, so for it'll be $12.75 for Miss Smith. That needs to be submitted within 7 days of today's date to the court. And then I have $12.75 on that one. And then did we ever determine, is it $15.68 on the other one? $15.58.
Is.
And then 1560 is the invoice.
All right. I'll order escrow in the amount of $15.68. Again, that must be filed with the court within 7 days of today's date or submitted to the court. I will indicate to the parties that if escrow is not paid timely, the court's intent will be to set an immediate trial pursuant to the court rule on both cases. Anything else on these?
Further remarks?
Oh, so look happy, right? Yes.
So, has funding application fee. And if that
Funding from,
emergency housing fund. And there's lots of units. If that should come through and a check is made to landlord instead of to the court, would that suffice?
if a check, if you provide to the court that there's payment and it's made to the plaintiff, I would direct plaintiff that they need to accept it. It would not be an issue. If is that going to cover the entire amount? If it's paid? I mean, if they approve it, then that would suffice for, well, that's for who, Miss Woods or Miss Smith?
She's starting a new job. I don't think she'll get a paycheck within 7 days. Just so the court is aware. It's a full-time job, but she will not get paid right now.
Well, what's cap on the emergency fund? Okay, but then the problem's going to be that I am going to be somewhere in the neighborhood of, what's that, it's 68. I'm going to be in the neighborhood of $6,900 on her case. So if 4 comes through, she's still going to have to keep up continuing rent. So, I mean, that assistance seems to me would be for back rent and not for future rent. So she would still have to, if she gets that funding, she gets that funding, but she still has to pay the rent going into the future. It would seem to me.
Correct, Your Honor. So that would
I
be,
understand where the court is going with this. When I don't know. Yeah, need to be pay down that. Initial And then I do have one other concern, Your Honor, regarding the order for escrow and the court saying there's gonna be immediate trial.
That's the rule. That's not just the court saying it. That's the rule.
Well, Your Honor, just hypothetically, the court lacks jurisdiction on the CARES Act issue, then how could a trial proceed
Your Honor,
before ruling on the motion?
respectfully, Your Honor,
I don't believe I lack jurisdiction. So
jurisdiction, I think that you're getting your issues mixed up, respectfully. The court has exclusive jurisdiction over these matters.
it may be why, Ms. Kim, and maybe your office should think about this, why when I issued my opinion, it was not an issue of subject matter jurisdiction because I don't think a federal rule divests this court of jurisdiction. And why I viewed it as an affirmative defense, which you could put forth for the court to rule on. I think that if people at your office had thought about it strategically, they probably would have agreed with me. But you chose not to. So now that's where you are.
I don't quite understand what you're saying, Your Honor.
I know that has been a problem. Anything else?
No, Your Honor.
All right.
That order stands, correct?
The escrow order stands. Submit that to the court. So sign off on it, please.
For both. What was the amount for,
That's okay. It was 12. I ordered for Miss Smith the amount of $12.75, and Miss Woods I ordered $15.68. What's think?
Thanks.
Oh, he needs to actually talk to me. Okay. What? Just Clark Road Family Housing versus Cindy Jim. And there's somebody else.
Not see the defense counsel here at the moment. He is in the court. He is in the courthouse. You want to pass this? I'll go check him out for you.
Well, I don't have anything necessarily past two, but if you could go see if
Yes, sir.
oh, find him.
I mean, he's just in the breakout room there.
On. Okay. And there's nothing contested. I've called the case, counsel.
Aaron, I'm sure about for the defendant. You know, versus not what's done.
He's T7 Lincoln Counter.
All right. I'm almost afraid to ask where we are on this, but I have 3 motions, I think, before the court.
Yes, in terms of my motion, I put forth a motion to withdraw as counsel to the breakdown of communications.
But you filed motions in limine also?
Yes,
And motions to compel discovery.
yes.
Okay, well, I'll hear those and then I'll hear your motion to withdraw.
Okay, and in regards to the motion the motion to compel the discovery.
Well, it's a motion to compel specifically depositions.
Yes. We put forth a motion to compel deposition as during our second court day, we respectfully requested the court consider depositions in regards to 3 people that we think are important in terms of the facts of this case. The things of the interest of justice. There's a numerous amount of allegations against my client. We think that these people have information that would be helpful in presenting a defense. There's a number of witnesses, a lot of allegations against my clients.
Why would I need a deposition of a police officer?
The police officer was involved in regards to the investigation of several complaints that have been alleged against my client.
So why would he need to be deposed, I guess?
That's what my client is requesting.
Okay. So there's not a basis other than a request and a wish or desire.
He wishes to speak himself if he can be heard.
Go ahead.
Morning, Your Honor. Thank you. The reason I've requested the position of Officer Lawrence is because, as we've alleged, this landlord has the management. The real reason for this lawsuit against us is retaliation, because I reported them to Commissioner. And that they have weaponized Saline Police Department.
These people weaponize Ipsy PD? Okay, you can stop there because that request is denied. Without more, that is absolutely denied. If you're going to tell me some landlord decided to weaponize the police department,
Well, not that.
that's going to be a complaint you're going to have to address as the police department. And I don't believe it. Why would the keeper of the records for the plaintiff need to be deposed?
Because that goes into the heart of the matter as well. When they started a plan, a motion to try to look at me, making me look bad, which then essentially led to this lawsuit for eviction. They committed certain acts in the office and on the body cam too, that I've actually reported all to, I should state, to strengthen my argument here.
What?
We find.
Is there a specific person you're saying did all those things? Because I don't know who you're referring to as the keeper of the record.
I don't understand keeper of the record, what does that mean?
Looking at your motion to compel depositions. Paragraph 8D. Plaintiff's keeper of the records.
Your Honor, I think what he's referring to in regards to that is he believes that there's information that will help exonerate him from the charges, such as video or cameras set up around the complex. And
have those been requested?
Discovery's been requested, yes.
And that was camera footage and the like?
All discovery was requested. even electronic discovery. So the full range of discoveries was requested.
And has plaintiff not provided it? I guess I'm not clear if it's been requested. Where does a deposition help with that?
And I mean,
Go ahead. I don't care either one of you because
Oh, okay, yeah, yeah.
I mean anybody can dig a hole for themselves. So go ahead. You two
Right.
bet it.
Well, there are certain acts behind the scene, which I think they've committed to the management to essentially weaponize a few other tenants too. Your Honor, we've filed a complaint with Michigan Department of Civil Rights. And we even met with the state administrator a few weeks ago, Cindy and I. And they opened up an official investigation on April 29th against the landlord for 4 items: retaliation, disability, and discrimination on the basis of national origin and sex. And that investigation is active. Plaintiff.
Okay.
Plaintiff's attorney.
Assume everything you say is correct.
Yes, sir.
Why do I need a deposition?
Deposition is to essentially dig for more information.
That's not the way that works.
That they've done. That's my.
Who is Paul Spencer?
Aaron, Paul Spencer is the CEO of K&G Prestige.
You can stop there. You can stop there. Why do you need his deposition?
Because Paul Spencer is the one who responded to an email that I sent to our Michelle board and him. My email was dated March 2nd. And within a few days, he decided to, and he emailed them saying essentially he's going to evict us. And they'll retaliate and against Sydney both. So it's important that Mr. Spencer is deposed.
Why?
I thought it would be getting some more information. My mind that we could expose more information for the clarity of this court.
So it's a fishing expedition.
Fishing expedition. Well, to try to find out what happened behind the scene. Sure, under oath to be deposed.
Who is Sheena Mickens?
She is the on-site manager who will be here at the jury trial to testify.
So why do you need her deposition?
She's the one who also made all these false and allegations against me, which are listed in the with summons, many of which actually don't apply to me. I found that on Saturday, just this past Saturday, because there were complaints by tenants who don't even live in our building, and it wasn't even about me. And they used those as a basis to file this complaint with this court. Which in my view is, well, it doesn't matter what my view is. So there's so much behind the scene that they've done. One of these complaints, actually, which I think may be valid, is a complaint by tenants who was essentially coached and helped and weaponized.
Everybody's being weaponized.
No, not everybody, but a few, yes, who got all the facts. She made allegations that are untrue, baseless, and so the responsibility in the complex for a poor maintenance job that they've done. They blamed me.
Have interrogatories, and I think there were interrogatories request for production and admissions.
Yes, Your Honor. We served the plaintiff that we received approximately 360 pages in terms of discovery. I served another request for admissions interrogatories just last week. So, I mean, in terms of what.
And all of those have been answered.
All right, if I may, we responded to the first set, gave it to him on Thursday afternoon. Friday, he drove another set to my office so
How
we
many-
got that to work on still, Your Honor.
How many interrogatories are there?
This is the second one that I drove is all.
Well, listen to my question. How many interrogatories are there?
He did not constitute it over when Your Honor. We're just gonna respond to him because we're not going to try and play those games.
No, I understand, but I also, in district court, you have to ask permission before you get any of that. I'm not saying that you didn't get the court's permission, that there could be limited discovery, but I also don't, I guess, allow discovery or use your client's phrase to be used as a weapon or weaponize it to try to bury somebody to do something. I mean, it seems to me that they've responded to the discovery request. I'm a bit concerned that then there becomes a second set of discovery. When this really is a landlord-tenant case. All right.
I would have to double check, but I think in terms of the number of interrogatories, I think it's under 30 questions. And then request for admissions, I think is probably like another,
So under 30 questions,
I think it's like 15 to 20 questions. I mean, sorry, 20 to 30 questions in terms of interrogatories, and about maybe about 18 or 20 request for admission questions.
yes.
I don't object to dropping the deposition. Actually,
You what?
I don't, I don't object to the dropping our request.
So now you don't want depositions?
Guys, I'm thinking a little bit more. The,
Well, that's probably good because your motion was going to be denied.
yeah, as a,
So I don't need a response on that motion, Mr. Gannon.
Yes, sir.
The motion to compel this depositions is denied. I would also indicate that at this point, plaintiff can answer the other set, should they so choose, as well as the request for admissions or the other set of interrogatories. But I'm not going to allow any further. I think the process is being abused. And so I'm not going to have any further discovery without the permission, express permission, and written permission of the court. There will be no further discovery.
Hey, we do have a set to them that's a couple weeks
To
old.
answer that, but any additional request, there needs to be written permission from the court to do so.
Yes, sir.
Motion in limine.
Your Honor, the motion limited was filed. I think that is, we're gonna withdraw that motion limited, see what plans provide in terms of discovery. And if appropriate, if I remain the attorney, maybe file another motion limited.
I don't understand why I have this now, if that was. In response to the motion in limine, Mr. Gann.
I did submit a response to it. I think the timeliness is the real issue here. How would you know what evidence you want to exclude without even knowing what evidence has been produced yet? In addition, there is a federal statute 24-247.6, which does allow landlords additional grounds for termination that were not known to the landlord at the time of the issue. And until discovery is complete, I think this is premature motion.
Well, this motion in limine, I understand they want to withdraw it, but I think we need to make this record clear. I'm going to deny the motion in limine. I think there were only three, right?
Let me draft an order for those two, Your Honor.
No, I have people that will do that.
Thank you.
Yeah. And the motion to withdraw.
Yes, respectfully requesting to withdraw. There's been a breakdown in communications in regards to this matter. That breakdown has remained for some time. I'm respectfully requesting to withdraw.
Nori, or do you have a response to that?
Yes, if I may, sure. I've asked Attorney Ogletree what specific examples, events, behaviors, words, anything. My part. It was right him to make that decision. That's in a few times the emails. He hasn't provided any specific examples. I usually try to have most of my communications via email. It's a matter of record. So it wouldn't be hearsay, my word against your word, and something. So, Ogletree told me that it's going to be teamwork. I said, great, collaboration. So I'd like to be as part of that. I'd like to be in the loop. And I should be with the clients here. It's something very important. And a few conversations took place and a few things we hashed out. I'm assertive, but very respectful. And I don't know which one of those things that we discussed between us set him off. I have no idea because he hasn't responded. So about 3 weeks into the session, or essentially the process, which was about 3 weeks ago, roughly, then he decided to withdraw. He said that I wanted to litigate the case. And I was disrespectful and demeaning to him. And he still hasn't provided an example to me. I've never disrespected him. I don't like him. And we have this professional relationship.
You guys probably need to figure it out, and I probably don't need to. Normally, I wouldn't stand in an attorney's way to get out of a case, but you're objecting. Usually, that's not the case either. So I'm going to, at this point, go ahead, counsel.
I'm limited in terms of
What you can say. I know.
Yeah. I mean, but I have put in writing in regards to this. I'm just trying to think of what I can actually say. There's not attorney-client privilege.
I get it.
My hands are kind of tied of what I can say. I would just say I think that at this point I may have a conflict with regards to this matter. And that's the only thing I can say.
How soon will we be ready to, well, I have a final settlement conference on the 7th, already set in this case. So on August 7th.
August,
What?
August 4th is the first.
Then you have.
Is it the 4th or 7th?
Oh, except for the 4th and then the 7th.
4th and then the 7th, right? Okay, got you. I think what I'm going to do on the motion to withdraw, and Mr. Jedidori, I just want to make sure I'm clear on it. You're objecting to counsel's motion to withdraw?
We need to have an attorney,
Pardon?
have an attorney.
Okay, but you don't need to have this one if there's a problem.
I haven't had a problem. As I said, I communicated and continue to communicate.
Well, maybe you guys can figure that out. What I'm gonna do is, when is the discovery due?
We just received another one on Friday, so that would be, you didn't put a close of discovery.
That was the second one.
That was the second. The first one we've responded to already. I believe we gave theirs to them a couple weeks ago, so probably 14 more days, I would assume, would be when that one's due.
You'd agree with that, counsel? About 14.
Yeah, roughly about 14 days, but I think what he's saying is he's asking for if there's some type of legal aid program that can appoint an attorney.
Well, you just saw him in here. You can go to legal aid. I mean, we'll give you a number to call them, but
We have already contacted them before, I mean, a while ago,
and
not recently, yeah. Well, yeah, even a couple of weeks ago when I was wondering what's gonna happen, they said that they're not, they don't have the resources for an attorney who's gonna be fighting.
all right,
We're wondering if the court could assign a pro bono attorney
I cannot assign an attorney on a civil case.
on a civil case. Oh.
I would just respectfully, again, just request to withdraw. Again, I believe I have a conflict in this matter.
What I will do is I will grant the motion to withdraw. Any notices, discovery, or anything like that are to be sent directly to the defendants in this case at the 939 West Clark Road, number 101, until further notice of the court.
We rescind the first set of interrogatories. Has that already been given to
Well, he's under an obligation to make sure that that they have them. I don't think-
So
Okay.
I received that for you.
All right.
And Your Honor, just for clarification, I know you've got it set for a jury selection. Is it August, September? At the end of August, I'm gonna be out of country, so I just want to make sure we don't miss.
I have it set for jury selection August 10th.
August 10th.
Right, August 10th for selection.
How run your selections, Your Honor?
Pardon?
How do you run your jury trials? Is
Very well, thank you.
I
But-
understood. As far as the timing, is it the next month, the next week, the next day?
It can be the next month.
Okay,
We'll work with timing in terms of, I work with counsel. If we select, I work with counsel in terms of timing of the jury selection. Also understanding this being a civil case, the
criminal.
criminal cases take precedent. I would also indicate has how much is monthly rent?
155, Your Honor.
Okay.
It's a, by the 7-day last week, an escrow order, as well as an order to have no negative contacts with all named.
Yes. So, well, I just wanted to make sure that escrow has been complied with, so it has been thus far. All right. Thank you.
Yes, question.
Yes.
Pay the May rent into this. I know you said starting as of June, but could we pay that to the courts too? But they didn't take the rent, May
We'll-
from us.
We'll never object to them paying more rent to the court.
Yeah.
As Part Forest required us not to take May.
Right. So you can pay the maid to the court. That's fine.
I can?
Yep.
Oh, okay.
Thank you, Your Honor.
Thank you.
Thank you.
Thank you.
Thank you, Your Honor.
That's all yours.
Yes, I can take all.
Huh?
I'll take all.
She's gonna do that. That's yet nothing to do. Who did? Mr. Ogletree provided an order, but I don't like his order. I have interns to do orders,
Okay.
and they do a fine job doing orders. Don't be so shy. Just be like me. Proclaim your greatness. Right. All right. Right?
Mhm.
Okay. It's a consent
Mhm.
order.
Yeah.
Okay, then you're okay. You can stay.
Yeah.
Or- no.
Yeah.
Well, wait, I'll call it slow. Is that the one?
Sure hope so.
But if I call it right now, she's gonna.
Oh, she's-
Well, we have to. No, you know what? I told people what to do. Huh? You think she's staying there? Too? No, I think she took off. She did? Okay, so we gotta wait just a minute because. And I told you what you need to do, that if she doesn't show up through those doors in a few minutes, then you got to go find her because I'm not explaining to her parents why I lost their child. What? If she did, no, don't check because I'm not explaining it. I'm just not. I don't know where your child is. I'm sorry.
Your Honor, it's a proud moment when the parents get to see the kids working for the court.
Pardon?
It's a proud moment when the parents get to see the kids working for the court.
It's better that they work for and not in front of. You know, that's the way I.
Daughter worked for Ben Graywall, who took down Larry Nasser, so she was fairly on that case. So.
Got it. Where? Doesn't take that long.
He also doesn't know who they are.
Is she lost?
She probably just take her time.
Why would she take her time? I told her.
So after that, resumes, which is gonna be this.
Really, man?
Second.
What?
Second.
Oh, you're staying? Okay, fine. I'm just gonna do it. I'm just.
Oh, you want me to go around to?
No, it's okay now because we were waiting for you to go around to the front, and then I thought.
She told
I
me.
thought, well, I know, but I thought I was gonna have to explain to your dad that we lost you, and I'm not. I wasn't doing it. And then Minori said she's gone. She left the building, and then I didn't know what to do, so I'm just gonna call her. Town Center Place versus Eugene Records. Embarrassing. Yes.
Good morning, Judge Mark Wasbury on behalf of plaintiff.
And sir, your name?
Eugene Rankins.
Thank you. And it looks like the parties have worked out a consent order for conditional dismissal.
Yes, sir. Yes, sir.
All right. And it indicates that you're going to vacate the premises and turn in the keys by August 3rd, 2026.
Yes, Your Honor.
All right. And that's a voluntary move on your part. That's the court's understanding of the agreement. Is that what you've agreed to, sir?
Yes, Your Honor, I did.
All right. Do you have any questions regarding this conditional order of dismissal?
I clearly understand, Your Honor.
Pardon?
I clearly understand.
Okay. And I'm going to sign this, but I do have to apprise you that you have 3 business days in which to think about it. If you think there's some legal reason, some right you didn't assert, or some other reason, then you could move this court to set it aside within the next 3 business days. You understand that?
Yes, Your Honor, I do.
All right. And again, no further questions on it, right?
Sir.
I would also indicate, sir, just so that we're clear on the record, you guys have worked out this agreement. The court did not issue a ruling on this case, right? I'm just signing off on this. That I would indicate that a family member for Mr. Wasbury does work for the court. And so if you don't want me signing this, I'm disclosing that to you. It has nothing to do with anything that I would do. But I'm disclosing that to you. If you want another judge to sign off, I can have another judge sign off on it.
Your Honor, that won't be necessary.
It won't be necessary? All right. Thank you, sir. And it's signed. Thanks, folks, for working it out.
Judge, I hope she wasn't leaving because she was embarrassed of me, but
Well, we'll talk. No. I think actually I embarrassed her by but that's the way we roll. So okay. All right, thank you. You're like, all right. She's like, look at she's blushing. Why are you? Can I have the Norman file? Can you hear us?
Yes, good morning, Susie Norman.
Thank you. All right, this is the time and date for the court's decision on this case. I've listened to the testimony from the parties and am prepared at this time to issue the court's decision. The first finding that I'm going to make in the case is, and I'm doing so because I think the security deposit, well, there are different amounts that are claimed. The leasing agreement clearly indicates that $3,500 was paid as a security deposit. That security deposit, so that the record is also clear, was not held as it should have been pursuant to statute. So there's nothing presented to the court that would indicate that this is an amount held in a separate account for this tenant. Therefore, that in this court's mind, that leads the court to the default position of looking at the leasing agreement, and it was the $3,500 the court will find that was paid or should have been attributed to the security deposit. There are then claims by the landlord, and without getting into whether or not the landlord has properly complied with the Security Deposit Act, I will come to that a little bit later. But there is a claim for damages Holloway and Holloway, which account for $1,090. In looking at that, the court does not, there is no justification that the court sees for the damages that are listed here to be applied to the security deposit, number one, because they're not really damages. Saying that certain things had to be carried away. And the court would find that the plaintiff has not sustained their burden as it regards that claim of the 1,090. The cost for blinds, the cost of the blinds in this case, there weren't really adequate proof per se of all of these blinds having to be replaced in the fashion that they were replaced. In fact, it only looks like there is 8. There is also this $250 labor charge, and it's unclear to the court because none of the people who did this labor, with the exception of the plaintiff in this case, has said in some ways that he did some of the labor. But I don't have any of those individuals there. I don't have a receipt or anything along those lines for what was paid to them. And so I will allow the cost, although it may be a bit high, I'll allow the cost of the blinds plus obviously something had to be done, but I'm not allowing the $250 in labor. I'm only going to allow $150 in labor. So that's, you're going to need to keep track of these numbers for me. So that is 200 instead of 361.13. It is going to be 261.13 that Miss Norman might owe for the replacement of the blinds. The window glaze removal, while I think that's a bit high, I will allow the $100 for the window glaze removal. I will, and I'm not going to have a dispute. I did see some screen damage to the premises, so I would allow that $100 for that. The replacement of the doors at installation is a huge problem because the cost that's attributed for these is $1,775 plus materials. So the doors themselves, the landlord has estimated at $211.47. But then the labor charge seems high and ridiculously high, quite frankly, at $1,775. Because it's so high, and I can't even figure out what it specifically is for, I'm going to disallow the entirety of that, with the exception of the material costs, which seems reasonable. Cost of the new locks to the premises, that also is a problem because I'm not sure again where this $100 an hour is coming from. I don't and didn't have, as I saw, a receipt for those locks, and I'm not sure that the locks needed to be changed or they could have been rekeyed for a lot less than these costs of new locks. I will, however, give the defendant $200, which I think is generous, giving some benefit, give the plaintiff that with some benefit to giving him some benefit that the locks even needed to be changed. There is a water and sewer balance. Again, I didn't get anything on this, and I don't know that that was due. It just says that. And I'm not going to allow it. Cost of the fridge drawer, I was not presented a receipt. for that. And so I'm not going to allow that. There is this writing on the walls, chalkboard, furniture, solvents and paint that he's charged $875 for. I see some of the pictures. Again, I'm having problems with these labor charges that the defendant is, or that the plaintiff is putting in here. And so I'm only allowing on that. I'll allow $500 for that. I think, again, that may be a bit of a high figure. But obviously there is some cleanup for some damages in that regard. This plumbing repair costs, the dry out flakes, the setup and the dryers and all of these things, I just don't think that's attributable to the plaintiff. And so the plumbing parts and repairs, because the landlord has to take care of the premises. Those are fixtures more than anything. So I'm not going to allow that. I'm not allowing the cost to dry out moisture. There becomes a problem in the unit, and the landlord is going to have to dry that unit out anyway. And that. Then there is this sort of overall cost of $1,200 for the cost of carpentry, drywall, painting. Now, what's interesting to me is there's like a double dipping, because previously in the list, there is a solvents, removal cost of writing on the walls, and that's not included in there. But I get to this particular item, and there is just $1,200. I don't have a breakdown of what's drywall, what's painting. I don't even have, is this labor? Is this materials? I have nothing. And so I'm not going to allow that. So I need $1,261.13, $200, $211.47, and then $700 brings me to what?
$2,372.
2,000. Say it again.
$372.47. You said 1261.
Oh, it should have been 261. So you got to take 1,000 off of that, right? So it should be 1,372. And how much?
It should be
1,372.
1261 and 13 cents, correct?
Got it. Yep. And then take that figure, take 3,500, subtract that figure out.
From 3,500.
Yes, ma'am.
$2,127.40.
So based upon the court's finding regarding the damages, the like, and that the plaintiff did not keep the security deposit as required by statute, I will also indicate that I am not, pursuant to the Security Deposit Act, doubling the security deposit for wrongfully withholding it. I am going to order, and I am going to order that the 1,372.60 be subtracted or deducted from the security deposit of the $3,500, and I will award a judgment to the defendant, Miss Norman, against the plaintiff in the amount of $2,127.40. And Ms. Norman, you need to submit to the court a judgment in that amount. You understand that? I can't hear you, ma'am.
Actually, I do not, but I have my notepad here, so I'll make notes and follow your instruction.
You need to submit a judgment to the court, awarding a judgment in your favor as against the plaintiff in this case in the amount of $2,127.40.
212740. Okay,
Yes, ma'am. Thank you.
thank you.
No, I didn't write anything. All right, Mr. Fink, how many do I have left?
You have 2 left.
I actually sent some paperwork to the court. I emailed it stating that it just started yesterday. And so with that new income information, I wanted to kind of present some type of proposal to pay.
So let me get this right. You two ladies started talking to each other and you guys may be able to work this out.
We always having a good relationship.
You know, when you guys were on Zoom, I could tell that.
It's, I was waiting for this moment since last year. So that's what I was holding the loan and the payment went up that much. But we understand and she understand that it came to a point that it was hard to me holding up more debt.
Yeah.
That's what I have to come to court because we were always having a conversation. It was a little bit sometimes rough because I was pushing because I need to pay. And
No, and just so you know, that happens a lot. Like you start pushing, you're not in a position to do much, but you kind of want to, but I can't make any promises because I don't have anything to back that promise. Right?
Exactly.
All right. Let me ask you this, folks. Do you guys need more? I'll work with you. Do you guys need more time to talk to try to work out exactly what you're doing?
I actually have a meeting at 1:00.
Okay.
Like I said, I just started this job yesterday.
No, here's what I'm saying. Well, and you got to figure out what your paychecks can be and what you can do.
well, we haven't get to that point. So that's why she wants to present what is the proposal because
Got it.
exactly what is her.
Okay.
I don't know what I'm gonna agree or not.
So rather than hold you today, because you guys are on a good path toward resolving it, I was thinking about adjourning it out,
Okay.
letting you guys talk to each other as long as you'll promise that you'll talk to each other. See what the proposal is, see whether or not that can work for you, and see whether or not it can be resolved. And if you need my help, then we can come back here and I'll sit down with the two of you to nail out any details we need to do.
What I can do is, I have an idea of what my paychecks is going to be like after tax.
Okay.
So what I'll do is, if it's okay with you, I'll put together a proposal. I can have it to you by Monday to kind of let you know
Yeah,
what I can pay.
right. But just remember what I mentioned to you. It cannot lower than what their monthly rent is, plus whatever they catch up to pay.
It definitely wouldn't be lower than
540.
Okay.
because it was lower because those contract, they're coming in so sporadic.
Ladies, let's do this. I'm going to adjourn you out 2 weeks. Put together your proposal, get it over, talk through any details. If you guys come up with something, then we'll meet here in 2 weeks. I won't hold you as long as I have today because we hopefully won't have what we had today.
Okay.
Get you out of here and do whatever. If you're working so that there's not a problem, or you both can, I will give, let Ann know that, oh, there you are, that I would allow you guys to appear via Zoom so that if we have to work it out, we can do it then.
Yeah, that's okay, but I work in the hospital, so I have to step out from his work.
Okay. So whichever is easier for you, okay? Just if there's becomes a problem with this date, then get to my staff. We'll figure something out for you.
Oh,
It would be July 14th, the Tuesday.
I have a day off on 14th.
Okay.
Okay, see, the only problem for me, and I'm not trying to be difficult. Taking more time is gonna be hard, so can we resolve it through paperwork? And then,
If you guys think that you can do that, then I'm not gonna have a problem with that. However you guys want to do it. I don't want to cause any difficulty. You guys are trying to work with each other, so I'm not.
I don't wanna mess up the payment, method.
No, I got you. So I'll adjourn the final settlement conference July 14, 2026.
James Fink for the plaintiff.
Your name, sir? All right. I had an opportunity to speak with both parties in this case, and we're going to enter into a judgment in this case where there would be a total amount due and owing, including court costs, of $6,303.09. That the defendant would have to pay that by June 16th, 2026, or an order of eviction could issue.
Your Honor, is that by consent or after hearing?
It actually probably should be after hearing.
Thank you.
What is nice? Said what? June 16th? So at some point you thought you could correct. It's July 6th. Is that your understanding? Okay. I didn't say June. No, I didn't. I don't care what you people say. All right. Anything you question about this or any questions you have, Mr. Perry? All right. And thank you folks for working it out. I've signed the judgment. Mr. Perry, if you want a copy, you can pick it up front at the counter. All right. Good luck to you, sir. That's it for us. 14A stands adjourned.
What happens when a defendant accuses an entire apartment complex and even the police of conspiring against him? That's exactly what unfolded during one of the most intense courtroom exchanges of the day. A tenant appeared before the judge asking for permission to take multiple depositions in an eviction lawsuit. According to him, the landlord wasn't just trying to evict him. He claimed the entire case was retaliation. He even alleged that the apartment management had weaponized the local police department against him. The courtroom immediately became tense. The judge listened carefully before asking a simple question. Why do you need these depositions? The tenant insisted they would uncover what had happened behind the scenes. He wanted to question police officers, the company's CEO, the property manager, and other witnesses because he believed they were all connected to the case. But the judge wasn't convinced. When the tenant admitted he wanted the depositions to dig for more information, the judge stopped him immediately. He explained that court rules don't allow parties to search for evidence without a proper legal basis. Then came the moment that changed the hearing. The judge looked directly at the tenant and said, "That's not the way that works." As the tenant continued arguing,